Hello and welcome to the course on Indian polity. Today we are going to start with the Article 19 of the Indian Constitution, and we are already discussing the fundamental right, that is part third of the Indian Constitution. In the previous video, we have discussed Article 15, 16, 17 and 18. In the Article 15, we have talked about the article is mainly meant for enforcing the social justice. That is, it prohibits the discrimination by the state and has given some grounds on which the discrimination is restricted. Article 16 provides for the equal opportunity in public employment. And we have seen that Article 15 and 16, wherein Article 15, Clause 1, Clause 2, talks about the fundamental right against discrimination, and the remaining articles are an exception to the Article 15, that is Article 15, Clause 3, Clause 4, Clause 5, and Clause 6. Similarly, in Article 16 also, we have seen Article 16, Clause 1 and Clause 2 are the fundamental right for equal opportunity in public employment. Whereas Article 16, Clause 3, 4, 4a, 4b, Clause 5, and Clause 6 are an exception to what the fundamental rights being granted under Article 16, Clause 1 and Clause 2. Then we have moved to Article 17, wherein we have discussed that Article 17 is an absolute fundamental right, whereas there is no exception to Article 17. And then we have discussed Article 18, which was the fundamental right against exception of any title, so as that quality, integrity, and unity of the nation could be maintained and loyalty of the Indian citizen toward its country could be ensured. Now, further moving onward, let us today discuss Article number 19, which is also not absolute. It comes with certain restriction, but I would say that it forms the core of the Indian democracy because Article 19 grants fundamental freedom to citizen of India, and it is only meant for the citizen of India and not to any person. So yes, Article 19 can be suspended during emergency and only if the ground of emergency is war or external aggression. So moving forward, let us start discussion on article number 19. So before going into the articles, let me give you a brief overview of how these articles are organized in the Constitution. We have article number 19, clause 1, which talks about the fundamental rights of freedom, fundamental freedoms. And then we have Article 19, Clause 2, Article 19, Clause 3, Article 19, Clause 4, Article 19, Clause 5, and Article 19, Clause 6. In Article 19, Clause 1, we will be discussing about the fundamental rights. There would be six fundamental rights. Article 19, Clause 1, Subclause A, 19, Clause 1, Subclause B, 19, Clause 1, Subclause C, 19, Clause 1, Subclause D, 19, Clause 1, Subclause E, 19, Clause 1, Subclause F, and 19, Clause 1, subclause G. Now, if you count all these subclauses, there would be seven. But we are saying that it talks about the Article 19 provides six fundamental freedoms. So that means one out of it, that is Article 19, Clause 1, Clause F, which was the fundamental right for property, has been repealed from the Constitution. And we have discussed this several times. So now we are left with only six fundamental rights that are mentioned under Article 19, subclause A, B, C, D, E, and G. And then each right is not an absolute right. It comes with certain restrictions, and the restrictions for each right are mentioned under clauses 2, 3, 4, 5, and 6. So these are basically what we talk about the restrictions on the fundamental rights, which is guaranteed under Article 19, Clause 1. So let us start discussion on Article 19, Clause 1. These rights are very straightforward and easy to understand. Not much interpretation is required in terms of understanding of these articles. So let us directly go with the article clause by clause. So the sixth fundamental of freedom under Article 19.1 is under Article 19 clause 1 subclause A, freedom of speech and expression, which is most widely discussed. And this includes right to express opinion, right to publish and print, right to criticize the government, right to silence, right to artistic expression. That is, you can do painting, you can raise banners and something, and the right to information. right to information comes from this freedom itself, and the government has enacted Right to Information Act also. So you see, 19 clause 1 subclause it talks about the fundamental speech freedom, fundamental freedom of speech and expression. That is, you are free to speak, express your feeling, to speak something if you want, and express. Now, expression, the term expression is very wide. How do you express yourself? You can express yourself in the debate, you can express by some poetry, you can express through media, you can express through banners. These are the forms of expression. So Articles 19, Clause 1, Subclause A, which talks about the freedom of speech and expression, is not a very simple one. It is widely interpreted by the court from time to time that yes, the sort of these activities, that is grouping together, raising demand, is also a form of expression, and it is guaranteed under Article 19, Subclause 1, Subclause A. So, yes, and this right is not absolute. There are some reasonable restrictions also, and which is mentioned under Article 19, Clause 2. And what on what ground your freedom of speech and expression can be restricted? That is, you should not express something, or you should not write something in the newspaper, or you should not your way of expression. Either you choose it the media, or you debate, or whatever way you choose to express yourself, that should not question the sovereignty or integrity of the India. That should not put the sovereignty or integrity of the India at danger. Should not risk the security of the state. Should not disturb the public order. Should not disturb the decency or morality. That means you want to express yourself. You have to ensure that the decency or morality should be preserved. That means spreading nuisance on the street under the shed or umbrella of the Article 19 subclause 1 clause 1 subclause A, that is, you have the freedom of speech and expression, does not give you the authority to break the decency and morality of the society. Then in the court you are free to speak unless and until you come in contradiction to the proceeding established in the court, that is the content of the court. And defamation, you are free to speak anything against anyone, that the particular guy is thief, or a particular guy is corrupt, uh, to the point that you are speaking the truth. If your intention is to defame him, to malign his character in the public, then that is prohibited under Article 19, Clause A, Subclause A. Under the freedom of speech and expression, you should not defame someone. Your intention should not be to defame someone. And that is the limitation under Article 19, Clause 2. Then incitement to an offense. And this has been widely used, that you have the freedom to express yourself, and you are addressing a crowd, and in the due process of what in the course of your speech, or you have used the terminology, or you have give a such outrageous speech that has that has resulted the crowd to commit violence or to commit offense, and that would come under the incitement to an offense, and that is also restricted under Article 19, Clause 2. So Article 19, Clause 1, Subclause A, freedom of speech and expression is very easily understood and not too much complex to interpret. However, what you can do, what you cannot do is straightforward under Article 19, Clause 2, that your result under the freedom of speech and expression should not come in contradiction, or should not be the outcome of all this prohibited statement that mentioned under Article 19, Clause 2. Other than that, you are free to do whatever you want to do. You are free to free to speak, free to express yourself, represent yourself, or present yourself in any way you choose. But that should not come in contradiction to Article 19, Clause 2. Hope that is clear. Let us move forward to Article 19, Clause 1, Subclause B, which talks about another freedom, that is freedom to assemble peacefully. You have the freedom to assemble peacefully, but you have to ensure that you are gathering, you are organizing a meet, the people are coming to listen to you. They You have a assembly, but the assembly should be peaceful. There should not be any arms. There should not be any source of violence. That means you have to ensure that you are, yes, you are coming together to discuss. And if you understand that that was the very basis why this right to assembly peacefully has been guaranteed as a fundamental right, because the very foundation of the formation of Congress was on this basis only, that let people come together and discuss the things, so that instead of directly committing a crime against the government, let them discuss the thing so that they could reach out to a solution, and then they can propose the solution to the government. And therefore, the right to assembly has been granted as a fundamental right, but the condition is you should be peacefully assembled and you should not assemble with the arm. That is, your purpose of assembly is not violence, is not an action against the government, is not for hampering of the public property, but to propose a solution, to discuss the issues, and mere assembly does not resulting into the offense or like you say fight or a quarrel something. So therefore, whenever you are organizing like a mass rally or something, you have to give or you have to take the approval from the district magistrate that yes, we are assembling. The magistrate will ensure that yes, if you are going to assemble, these are the terms and conditions you have to satisfy, and then otherwise the organizer of the assembly will be held responsible. So under Article 19, Clause 1, Subclause B, you have right to assemble peacefully, right to hold meetings, public gatherings, and procession, but the only condition you have to satisfy is that it must be peaceful and without arms. The reasonable restrictions and for this mentioned again under Article 19, Clause 3, and that is the public order and sovereignty and integrity of the India should not be tempered by your assembly. You are not assembling to raise slogans against the government or something that demanding an independent state or something like that. That would be obviously risking the sovereignty and the integrity of the country. Moving forward, Article 19, Clause 1, Subclause C, which talks about right to form association. Now, assembly is a temporary one. That means today you are assembling together for some temporary purpose, and then the purpose is gone, the assembly is gone, and it is like organized for a temporary purpose, not permanent. But the association, unions, or cooperative, these are permanent in nature. So also under Article 19, Clause 1, Subclause C, you have the fundamental right to form association, unions, and cooperatives. That is societies, cooperative societies. We have so many cooperative societies. The best example is the Amul. Then you have the unions, trade unions. You have associations, cooperative societies. Then you have the sports association, sports club. All that is you are able to form because you have the fundamental right. And why do you form the association? So that you could have the collective bargaining. Collective bargaining. What do I mean by this? See, being a resident of a colony, this is my colony. I'm an individual resident, and our colony is suffering from say a water problem, water supply problem. And I individually, if I go to the municipality or the local MLA, he will definitely not be give so much emphasis because of my individuality. But if all the people of the colony forms an association or form a union, and they from the then and I be chosen as the head of the union, and if I go to the MLA and not representing myself as an individual but as the representative of the union, which is the union of all the people of the colony, definitely I will have a different emphasis and weightage on my conversation. So that is what collective bargaining. That is, instead of bargaining with the representative or the authority individually, it is better to sit to a talk, not individually, but in a collective manner. So for that, you have to form association, unions, and cooperative societies, and that guarantee is given under Article 19, Clause 1, Clause C. Again, would be some reasonable restrictions, and that restrictions is that public order, morality, and sovereignty and integrity of the India of the country should not be hampered. So today, the citizens are allowed to form unions, clubs, political parties, and cooperative societies that we see. Moving forward, Article 19, Clause 1, Subclause D, it is having the right to move freely throughout the India. Do you require any visa or any ticket to move, like any visa or any permit to move from one state to another state within the territory of India? No. except for the northeast region. You required the inner line permit for some of the state. That is, if you want to enter the state, you have to carry that document, that is inner line permit, and that is for the security purpose. That inner line permit is granted. Except a few of the northeastern state, do you have any difficulty to travel from Madhya Pradesh to Gujarat, or from Gujarat to Maharashtra? Do you have to produce some document? No. You, being an Indian, that is enough for you, that you are an Indian and you have right to move freely throughout the country. You can go anywhere from Kashmir to Kanyakumari, and from Gujarat to northeastern state, let's say suppose Assam, and then you do not require to acquire some additional documents to travel throughout the country. So why do you do not require it? Because you have the fundamental right under Article 19, Clause 1, Clause D. But are some restrictions under it also. You cannot go freely into some tribal. You might have heard the news of the traveler went to the tribal area of the Andaman and Nicobar Island being killed, and the reason was that because the tribal people thought that there is an infringement to their culture, and therefore such an action was committed. So there are some restriction obviously, and that restriction is given under Article 19 Clause 5. There are some tribal areas, there are some restricted areas in which you cannot go roam around freely, and that is a few, and therefore that are some exceptions, and that you count under the restriction under Article 19, Clause 5. That is, the restriction is that your movement should not result in breaching the security of the state. That is, for example, say suppose some area, even in the states, that there is the area which is under the army, in the protection of the army or the supervision of the army, and you restricted that you cannot come inside that. So that is for the security of the state, maintenance of the public interest and protection of the scheduled tribe. So restricted areas in the tribal region where you cannot roam around freely, you have to go. If you want to roam in this area, you have to take the permission from the local panchayat or the gram sabha, and you want to say that I want to explore these tribal areas. So the tribal leader will accompany you, and he will guide you the norms that you have to obey in the tribal areas, because they are very concerned about the cultural, about their culture. And any infringement to their culture is a direct attack on their ethnic culture that they have been preserving so long. So to preserve that thing, there are some restrictions. The first restriction is that the security of the state and the maintenance of the public interest, and then the protection of the scheduled tribes. And therefore, some tribal areas are also restricted where you cannot move around freely. Other than that, you are free to move anywhere throughout the India, and that is also due to the fundamental right granted under Article 19, Clause 1, Clause D. I hope these articles, the rights under the Article 19 are very simple and self-explanatory. The restrictions you have to remember, and most of the restrictions are concerned about the sovereignty and integrity of the India, security, public order. So, in generalized, even these points need not to be remembered specifically. Like, for example, under Article 19, Clause 1, Subclause D, you have to remember that the protection of the scheduled tribe is one of the restrictions under Article 19, which prohibits your right to move freely throughout the country. So, moving forward, Article 19, Clause 1, Subclause E, which talks about right to reside anywhere in India, anywhere in India, and you can live in any part of the country wherever you want to stay, provided that you have the capability to buy the land or buy the flat. If you want to stay there, or if you want to stay on the rent, you can go anywhere in the country. You will be allowed residence over there. So you have the right to resident anywhere in the India. Again, there would be some exceptions, and exceptions would be same as under Article 19, Clause 5. You cannot go and stay in the tribal areas. You say that I want to stay here. Then there are some states which are protected where you cannot buy land. Some areas are protected where you cannot buy land. And also that protection is also because they want to preserve their culture. They want to preserve that the particular area should only be inhabited by the people who are originally belonging to that particular area. Because see, if the people from different cultures come and stay in the area, the culture that is originally the identity of that particular area will get mixed and get diluted, and over the period of time may also get extinct. So to protect that, right to move freely and right to reside anywhere in India is obviously are restricted by the same sort of restrictions under Article 19, Clause 5. So same restrictions need not to go again on that. Moving to the last fundamental right under Article 19 is mentioned under Article 19, Clause 1, Subclause G. We say that right to practice any profession or any trade. You have the fundamental right. You want to do any kind of business, any kind of profession you want to choose, or trade you want to carry on in the country, you can do that. Um Obviously, by profession means you can choose to be a doctor, engineer, provided that you have the degree. 19 clause 1 clause J specifically is mentioned in the constitution. Even though if it is not mentioned in the constitution, then there could be why it is mentioned in the constitution, because at this scenario you may not be able to think of a situation like that. But let me tell you, earlier, long back in 19 like say 40s and even before that, what was happening that a particular, very strictly the people were following what we call frankly as a Varna system. That is the particular, the people interpreted it wrongly. That is a separate thing. But the thing was that in the Varna system, it was said that it was Brahmin, Kshatriyas, Vaishyas, and Sudras. They were four Varnas. And the people who were the Brahmins will only can follow the profession of priest. But the reverse was actually true. Those who were the priest will belong to the Brahmin Varnas. Those who were the fighters or the soldiers will be coming to the Kshatriyas. But over the period of time, the interpretation changed, and then it became that if you are Kshatriyas, then only you can become the fighter. If you are Brahmin, then only you can become the profession, and that what continues to followed later, that even like after the Vedic culture ends, and this the reverse process continued up till now, I'll say. But when the constitution was enforced, that this process was gone away. Even if you are a Shudras and you want to become a soldier, you can join the Indian Army. That is, you have the right to practice any profession or any trade. There is no restriction in that. Okay. So you can start a business, you can practice any occupation, or you can run a trade or an industry. Obviously, there is some protocol that you have to follow. You have to do some registration. That is right away. And that qualification, whether you are eligible to possess that qualification or not, that is a separate thing. But yes, if you qualify, you will not be discriminated on the grounds, and you will be allowed to start a business or run a trade or an industry. The restriction is given under Article 19, Clause 6, and this is the last article of the under Article 19, the right to freedom. That is the professional teaching qualification must be required. See, this is the restriction clearly mentioned in the article itself. And if you want to become some professional expert in some domain, you must have that qualification. Then obviously public interest, there should be a reasonable restriction on that. And monopoly of the state, you will not say that, yes, sir, I want to run a railway station. I want to launch my own train. No, because only in those sectors you are open to do a business where there is no government monopoly. So if there is a monopoly of the state, you cannot come into that business. Okay. Some very critical form of business, very important for the national interest. The government has reserved that thing for itself. You cannot start trading or practicing business on that domain. But that they are very few. Apart from that, obviously you are right to practice and any profession of your choice, or to run any trade or any industry. I hope Article 19 is clear. It was very simple and self-explanatory, in which we have, in totality, six fundamental rights, and we have seen the reasonable restrictions to each fundamental right. Now, let me talk about the right to internet. See, right to internet, nowhere mentioned under Article 19, right to internet. It is not a direct fundamental right, but yes, it is a derived fundamental right, and it has been derived. It is a derived fundamental right. Derived fundamental right, and it has been derived from Article 19 itself, Clause 1 and Clause A, which you have the freedom of speech and expression. And if you are not, like, if you want to express something, you can come to the social media, you can come live on Facebook or YouTube and express yourself And for that, you require an internet. And then you have Article 19, Clause 1 and Clause G, which we have seen, that is, you have right to practice any profession or any trade. You have right to run an online coaching business or an online e-commerce platform, or you have somewhere a blogging or something you are doing online. You can go online and you can also practice, because the nature of trade has been evolved over the period of time. And that is why the internet has become one of the backbone to exercise these fundamental rights: freedom of speech and expression, and freedom of profession and practice any trade. And therefore, from these two fundamental rights, Article 19, Clause 1, Subclause A, and 19, Clause 1, Subclause G, the right to internet has been derived. And therefore, the Supreme Court of India has held that the right to internet access is protected under the fundamental right. So, right to internet is also a fundamental right. It is not a direct fundamental right, but it is a derived fundamental right. So, there was a case. Let me discuss you so that you could remember in the form of the story. There was a famous case known as the Anuradha Bhasin versus Union of India. You can go and search it on the internet if you want much of information in this case, but not required, just so that you can relate these articles in the form of story. I'm telling you, this was the case in 2020, Anuradha Bhasin versus Union of India case. And in this, the Supreme Court held that yes, internet access is constitutionally protected, that we have already discussed. What would be the restriction on this? The restriction would be same that we have the restriction mentioned under Article 19, subclause 2. These are the restrictions. So yes, tomorrow the government, if feels that the sovereignty and integrity of the India is at danger, it may block the internet access. It may restrict your right to internet, but cannot restrict forever. That means the shutdown of the internet cannot be indefinite. Why the Supreme Court explicitly mentioned this, that you want to restrict the fundamental right, and why this right to internet is evolved as the fundamental right. The story behind that in the state of the Kashmir, in some regions, the internet service has been blocked for months and even for more than that. And you may imagine, if on a single day your net is not working, you become so unrest, you feel so unconnected. And yes, if you are doing a business online, your business is like totally shut down, because that is totally dependent on the internet. So Supreme Court said that yes, the right to internet is a fundamental right, and you cannot shut down internet for indefinite period of time. It may be temporary or proportionate, and it should be reviewed. If you are shutting down an internet because you have the authority under Article 19, subclause 2, where you are ensuring that there is a security of the state at stake, or the sovereignty and integrity of the India is at stake, and for that purpose you are shutting down the internet. You cannot do that indefinitely. You have to review the reason for which you have shut down the internet after every 7 days, and that too not by an individual person, by a committee should be there, who should review that whether the internet should be shut down for 7 days, whether this should be extension or not. And then if there is not a reasonable reason for the shutting down of the internet, the right to internet should be restored. And you should have the orders. This is what the Supreme Court said in Anuradha Bhasin versus Union of India case, that you should publish the order clearly stating the reason. You should display a public order publicly, that yes, because of this particular reason the internet service will be struck down from this period of time to this period of time, that you have to clearly mention. So, Anuradha Bhasin versus Union of India case is what we say as the root for the right to internet. Now, do not get confused that right to internet means that you have a mobile and you should get a internet access. Uh, right to internet, what does it mean? It does not mean that you should get free data. That tomorrow you say that yes, sir, this you have got that right to internet is our fundamental right, and also under Article 32, I have the constitutional remedies that if my right is violated, I'll go directly to the Supreme Court and then file a petition that my right is not been enforced. Kindly enforce that. Cannot do that. and should not do that, because why? See, the way you are interpreting the thing is different. You have to understand what the actual meaning of right to internet is. It means that your access to internet, that means your access to internet is protected. Your access to internet is protected. You will not be blocked anywhere. If you have a mobile, and if you have the eligible data pack, then you can easily connect to the internet. There should not be restriction. So the government restrict that I am having my mobile, have recharged with the with the valid data plan. Still, I'm unable to use the internet. Why? Because the government has blocked. The government has blocked. I'm unable to access Google. Why? Because the government has blocked this site. That should not be. The government cannot block any site, or they cannot restrict your access to internet. Or but they can do that under Article 19 Clause 2, where there is a restriction. They will put an order, public order. Yes, due to this sort of restrictions, this sort of threat to the security of the state, to the sovereignty and integrity of the state, we are shutting down or restricting the access to particular site. For example, pornography is prohibited, so you will not be able to access the sites that are involved in spreading a pornography. So therefore the access to those sites has been blocked. On what ground? On Article 19 Clause 2, restrictions on decency and morality of the state should not be hampered. And under this restriction only, the pornography has been blocked. So means you cannot shut down. What does the right to internet means? You cannot shut down the your internet. Nobody can shut down your internet arbitrarily. That means you will have the access to internet. Everybody will have equal access to the internet. Cannot deny you the internet access when it is needed for livelihood or educational purpose, and cannot block the websites without following the law. If they want to block some website, there must be a law. There must be a public order, and the law backing or the order must be backed by the reasonable restriction mentioned under Article 19 Clause 2. I hope that is a clear understanding of right to internet and what are the fundamental rights that has been mentioned under Article 19, and the various restrictions under Article 19 subclause 2 to Article 19 subclause 6. Now let us move to the next important article, that is Article number 20. So Article 20 is the fundamental protector for every person. And when I say every person, it means both the citizen, whether you are a citizen of this country or you are not. It provides the fundamental protection who are accused of crime. See, merely being an accused of crime does not mean that you are a criminal. And even if you are accused of a crime, you have some fundamental rights guaranteed under Article 20. So tomorrow, if a police arrest you, or if there is some charges or criminal charges against you, then you have some rights that you can exercise. So it ensure a fairness in the criminal law and prevent misuse of power. Because even you are a criminal, even if you have committed a crime and you are a criminal, uh, then also you have some fundamental right. So Article 20 of the Indian Constitution gives three powerful protection in criminal cases. So what are those powerful protections? We will see that has been mentioned under Article 20 Clause 1, 20 Clause 2 and 20 Clause 3. 20 Clause 1 specifically says that no ex post facto law. What does this mean, no ex post facto law? It means that, say, today, today I have committed a crime. Let's say, suppose crime X. It may be of any nature. I have committed a crime. So in the we have told this. I have told this so many times that you are free to do anything and everything unless and until you come in contradiction with the law. Now I have committed a crime X, and this crime X is not yet this activity X is not yet made a crime. Not yet made a crime. For example, telling a lie or abusing in public. Abusing in public is not made a crime. So today I was abused in the public. So tomorrow, if it is a crime, so it should not be that those individual who was abused in the public yesterday also will come into the picture of that law. because the law is passed on, say, 22nd of January 1950, it will only be applicable to the it will only be applicable from this date onward, not below that, before that. So if I committed a crime 21st January 1950, I am free to do that because the law has been passed on 22nd January 1950. So I'll not come under this period. If I commit a law from this date onward, then only I will be found guilty under the law made, because the law has been enforced on 22nd January 1950, and till 21 January 1950, even though I have committed the same crime but there was no law contradicting, so I have no I would not be charged under that law. So that what is called as no ex post facto law, meaning a person cannot be punished for an act that was not an offense at the time when it was done. Also, if the punishment is increased after the act, the person cannot be given the harsher punishment. Yesterday, I committed a crime for which there was fine of 500. Tomorrow, the fine has been increased to 5,000. So I have been found guilty today. So I'll only pay 500. Tomorrow, if I have found guilty, I will pay 5,000, because tomorrow the fine has been increased, not today. And that tomorrow the fine has been increased, it will not be applicable to the previous days. So a law made today will have no effect on the previous crimes, will only have effect from today and onwards. So if something becomes a crime in 2025, you cannot be punish someone for doing that act in 2024. I hope this is clear. Now, Article 20, Clause 2, no double jeopardy. If you have seen some movie, you have seen that the Ravi Kishan was getting hanged. He was getting hanged, and the what we call as the जल्लाद जो फांसी पे चढ़ाता है, वो लेकर आता है और उसको फांसी चढ़ाता है। और जैसे ही फांसी चढ़ाता है, वो फांसी की रस्सी जो है वो टूट जाती है, रवि किशन नीचे गिर जाता है, बच जाता है और उठ के हंसने लगता है। तो वाई व्हाट इज द रीजन बिफोर हिज लाफ? इतना तो उसको भी मालूम है, उनको भी इवन द क्रिमिनल नोज कि इवन द क्रिमिनल हुआ क्रिमिनल ही नोज व्हाई हिज राइट, स्पेसिफिकली अदर राइट्स उसको मालूम हो ना हो, उसको अपने राइट्स मालूम है। उसको मालूम है कि देयर इज नो डबल jeopardy अंडर आर्टिकल 20 क्लॉज 2, व्हिच मींस दैट आई कैन नॉट बी punished फॉर द सेम क्राइम ट्वाइस। एक बार मुझे पनिशमेंट के लिए फांसी पे चढ़ाया गया, फांसी की रस्सी टूट गई, my punishment is completed. Now, even though I did not die, that is not my fault. I would not be punished again. And that is what double jeopardy means. That a person cannot be prosecuted and punished twice for the same offense. This applies only when the person has already been prosecuted and convicted once. Departmental administrative actions may still continue because they are not criminal prosecution. So departmental and administrative actions is different. Criminal prosecutions are different. We're talking about the criminal prosecutions. Remember that. So there, double jeopardy. No double jeopardy means cannot be prosecuted or punished twice for the same crime that you have committed. Once you have committed the crime, only once you will be punished, not twice. Moving to Article 20, subclause 3, which says that protection against self-incrimination. Nobody can compel to record my statement. Nobody can compel me to give evidence against myself only. That is, an accused person cannot be forced to give evidence against himself. Now, giving evidence against himself means what? That means nobody can force me to record an statement. To record an statement कि साहब मैंने ही नशे की हालत में उसका मर्डर किया या मैंने ही चोरी की, है ना? कन्फेशन जो बोलते हैं, कन्फेशन देने के लिए कोई मुझे फोर्स नहीं कर सकता। इसीलिए जब पुलिस आपका कन्फेशन रिकॉर्ड करती है, तो आपसे बोलती है कि क्या आप पे कोई प्रेशर बनाया जा रहा है, अपने विल से आप कन्फेशन दे रहे हैं? हाँ। जब आप जज के सामने जाते हैं, तो इवन द जज आस्क यू, आर यू सेइंग दिस आउट ऑफ योर ओन विल? एंड द मोमेंट यू से नो, आई हैव बीन कंपेल्ड टू से दैट, that statement or that confession is termed as null and void. Why? Because of the Article 20, Clause 3, which gives protection against self incrimination. So, the important point that should be remembered under Article 20, Clause 3 is that applies only to the accused person, not to the witnesses. I am accused, I am accused of the crime. This protection is given to me. If somebody else has seen me committing the crime, he can give the confession, he can become the witness, he can get his statement recorded. So protects only testimonial evidences, that is statement and confession. Tomorrow, I cannot say that you cannot take my DNA sample, you cannot take my biometric, you cannot take my retina scan because I have protection against self-incrimination. No, that is only for your statement and your confession, not for your physical evidences. So it does not protect physical evidence such as the fingerprints, blood samples, handwriting, etc. Confession must be voluntary, otherwise it is invalid. I hope that is so much about Article 20 is clear, very vivid. And these articles, that is Article 19, 20, 21, and onward articles, are very clear in understanding. But before we move to Article 21, which is the most elaborated article under the fundamental right, let us discuss an important case which is called as the Nandini Satpathy versus P.L. Dani. The case was Nandini Satpathy versus P.L. Dani, 1978. And this was the case for the interpretation of Article 20, Clause 3. What was the case? This Nandini Satpathy was a former chief minister of Odisha, and she was called for the police interrogation, and she was given a long list of questionnaires, and she was asked to answer them. She was well aware of a fundamental right under Article 20, subclause 3, and she refused, claiming that I'll not answer a single of your questionnaire because I have the fundamental right to not to give any evidence against myself, and that if I give give any of the answer to your questions, that would be the violation of the fundamental right, and you cannot prohibit me or you cannot prevent me in exercising my fundamental right under Article 20, Clause 3. So the case went to the Supreme Court, and the Supreme Court said that yes, the accused cannot be forced. You cannot be forced to answer the questions that may expose them to criminal charge. मतलब मार पीट करके आप मुझसे जबरदस्ती ये नहीं बुलवा सकते कि मैं चोर हूँ. आपका काम है, आप प्रूफ करो, you collect the evidences, even if I am a thief, even if I am a murderer. That much right I have been granted under the constitution. I would not say a single statement, I would not utter a single word that would expose me to criminal charges. You cannot beat me to the extent, you cannot compel me by any means. And that right has been granted to me under Article 20, Clause 3. So, see, you have, even if you are a criminal, our constitution has beautifully protected you, that you have the right. And why? Because if you see, the constitution is drafted long way 1950. At that case, they were the common incidents that the upper caste people, even though they commit the crime, they put the blame on the lower caste, and the police used to beat them up to record their confession and put them behind the bars. And today it may seem irrelevant, or like it may seem that why such Article 20 Clause 3 has been put. But at that time it was very relevant, and even though that practice is prevalent in the villages and even in some remote areas as well. So, not going into that detail of the of the social security, let us just limit ourselves to Article 20, Clause 3, and the content that it meant. I hope that is clear. So, let us move to Article 21 of the Indian Constitution, which is one of our most powerful fundamental rights. It says that no person, again I say that no person shall be deprived of. See, it says that no person, first point to highlight is no person shall be deprived of life, of his life, okay, and personal liberty. Okay, three things that you have to understand: no person, life, and personal liberty, except according to the procedure established by the law. This is what the procedure established by the law. No person shall be deprived of his life or personal liberty except by the procedure established by the law. This right is available to both citizen and not citizen, and this is what no person means. Even if you are a citizen of the country or not, you will be granted this fundamental right. So this point is clear. Now what we are left with is deprived of his life and personal liberty and procedure established by the law. So Article 21, if you see, includes many essential rights today, and this is like one of the mostly elaborated, mostly interpreted right by the Supreme Court. And over the period of time, it included so much right, and why it has done so we will discuss in due course of time. But you should understand that Article 21 is one of the most and more important fundamental right, interpreted very broadly by the Supreme Court. It ensures that the state cannot take away his personal life, the person life, or its liberty, or its freedom, unless there is a fair, just, and reasonable legal process. We will discuss each and every point. Just be patient. Article 21 today's include many essential right and many essential right. We will see the list of all those essential right which comes under the preview of Article 21, which is derived directly from the Article 21. So we can say that Article 21 is the heart of the human rights in India, protecting both our freedom as well as the quality of life. Why? See, first of all, let me remove all this. And this is one of the most important law, most important article says. No person shall be deprived of his life. Deprived of his life means nobody can kill you, can murder you, and take away your life. So, right to life. You have the right to life. That means you have the right to life. What does life mean? Is it mere living? Is it mere living, mere taking breath, exhaling and inhaling? Is that the life? Or life means to live with dignity, to live peacefully, to live in harmony. So, what is the interpretation of life? And the interpretation of life has been done by Supreme Court from time to time, and that is why the Supreme Court has said that right to life, okay, it means right to life means to right to live with dignity. Right to live with dignity, you required all this thing. You required electricity, you required house, you required clean water. All this is related to live with dignity, and then therefore it is related to right to life. So right to life itself is very elaborative. Again, the Constitution only mentions the right to life, but its interpretation, it is left to the final interpreter of the Constitution, that is the Supreme Court, and which has interpreted beautifully in so many instances. Then the second part comes the personal liberty. Liberty here means freedom. Now, my personal freedom. Already, the Constitution has granted me six fundamental freedoms. We have seen above Article 19, Clause 1, Subclause A to Article 19, Clause 1, Subclause G. All the six fundamental freedom. So what does personal freedom this Article 21 talk about? It talks about my personal liberty. My my personal liberty means bodily liberty. That means freedom of a body of a person. I cannot be arrested. I cannot be detained. I cannot be. It subsumes the freedom mentioned under Article 19, but is much more elaborative than that. It includes all the freedoms mentioned under Article 19, that I want to go anywhere, I should go, I want to do anything, I should do, I should be able to do, but it is more elaborative than that. The next point that comes is the procedure established by the law. You see, what does this word mean? That except I should not be deprived of my life, I should not be deprived of my personal liberty, except this is the restriction, except according to the procedure established by the law. There should be a procedure, there should be a method. Where should be the method mentioned? It should be mentioned by the law. If you understand this point, the article would be clear, become clear. There should be a method, and that method should be established by law. Okay? That means tomorrow, if I pass a law and I say that, yes, if this person speak lies three times, you give him sentence to death. STD sentence to death. So, and this law is passed. Law is passed by legislature, the parliament. The parliament passed the law. It said that if tomorrow anybody speak lies for three times, put him to death. Take his life away. Give him a poisonous injection. Do not hang him. Give him a poisonous injection, or burn him. I want, this is like, suppose say this is my way. I want to burn him liar, so that nobody from tomorrow onwards speak lies. Burn him to death. That can be done. What does the statement say? It says that Yes, nobody shall be deprived of his life or personal liberty, but except according to the procedure, that is the method procedure established by the law. Okay. Yes, I have a law. I made the law. It is said that there should be a law. Yes, and there should be a procedure established by the law. This is the procedure. If you speak three times lies, you will be burned to death. So there is no wrong. There is no violation of Article 21. So what kind of liberty do I have? I cannot speak lie three times. Suppose saying a lie is a crime. There are much bigger crime than that. For that, I am not being burnt live, but for speaking lies, I am burning live. I am burning life to death. So what right to life I have? What personal liberty I have? I do not have any life to liberty. So the question was, okay, tomorrow if I am burnt, tomorrow if I have been burned alive to death, so only the article means it will only check whether I have spoken lies three times. Yes. If I have spoken lies three times, whether there was a committee to review that my lies were truly lies, it was not fact. If the committee approve, yes, it was all lies, then I will burn to that. This is the procedure. So, is it only concerned that the procedure should be followed? Whether step 1 has been done, step 2 has been done, step 3 has been done, or step 1 has been done and step 2 has been violated and directly step 3 has been raised, then the Supreme Court will say that yes, you have not followed the procedure completely and therefore this is a clear-cut violation of right to life and it should not be burned to death. And if all the procedures step 1, 2 and 3 is followed, I can be burned to death. Is that the way the Supreme Court should behave? And you will be shocked. Yes, the Supreme Court said yes. In the very famous case, Gopalam case in 1950, it says yes. The procedure established by the law, this word, the procedure established by the law, does not put restrictions on the parliament, on the legislature. It only put restrictions on the executive. That is, the executive who are executing the process, they have followed properly the process or not. If they have completely followed the process, then it is okay. Whatever is the law, there is no restriction on the parliament. So this is what Supreme Court held in Gopalam case 1950. He said that yes, the Supreme Court said that yes, this procedure established by the law, the procedure established by the law does not put any restrictions on the parliament. He can pass any law unless and until it is violative of the like provisions of the constitution, and till the extent there is a law and a process, the only restriction is on the executive, that whether the executive has followed the process or not. Now before I move forward, let me leave you here with this Gopalam case 1950, and let me give you a space to question yourself, why was this judgment given and why was this interpretation given, and let me introduce a new term which is known as the due process of law. Due process of law, what is this? This is an American concept. In America, we follow the due process of law. In India, it says that the procedure established by the law, but we follow due process of the law. At this moment, let me pause and let me just give you a quick revision where we talk about the Article 14. We said that the equality before the law and equal protection of the law. And we said that the equal protection of the law has been taken from the British origin, where we talk about the rule of law, taken from the British judge or A.V. Dicey theory of rule of law. Here also, the Article 21 talks about the procedure established by the law, which we have understood, and the interpretation by the Supreme Court under the case Gopalam case 1950. Now let us understand what is due process of law, which is an American concept. In the due process of the law, it says that no person can be deprived of life and liberty, similar to Article 21, unless there is a law. But the law should be the additional thing that you have to remember in due process of law, that is there should be a law, the process for must be followed and that process should be mentioned in the law, but the law should be fair, just, reasonable. The law must be fair, it should not be unfair, it should not be unjust, and reasonable. Also, the procedure followed is also fair and just. So, the due process of law means nobody shall be deprived of your life or liberty unless there is a procedure established by the law, but the law should be fair. it should be just, it should be reasonable, and also procedure that is being followed should be fair and just. That is the extra protection given in the due process of the law. So, in simple word, the law must be fair, the procedure must be fair, and decision must not be arbitrary. Arbitrary. That is what the due process of law means. This concept protects individual from unfair laws and unfair actions of the government. And you see, this is the unfair law and unfair procedure. So, India does not follow due process of law, but follows the procedure established by the law. And this is what the literal interpretation made by the Supreme Court under the case Gopalam 1950. But you know that the interpretation, the final interpreter of the Constitution is what? Supreme Court. And tomorrow, if the Supreme Court will say that the procedure established by the law does not limit itself to the law only, but also includes the due process of the law, that is, the law must be fair, just, and reasonable, then it has to be followed. And that what happens in the very famous case that we call as the Menka Gandhi versus Union of India case of 1978. See the very same year in which the Nandini Satpathy versus PL Dani case we have discussed earlier. So before we move to the case, let us complete this. Right to life does not means mere animal existence. It includes live with dignity, with safety, and meaningful quality of life. And right to personal liberty means the freedom of body and person. No one can be arrested, detained, or restricted without lawful authority and a fair and a just procedure. So, the procedure established by law, originally it meant that any law passed by the parliament was enough, even if unfair. But after Menka Gandhi versus Union of India 1978, the Supreme Court held that the procedure must be just, fair, reasonable. That is, if law violates natural justice, it is unconstitutional. So, in India, instead of the due process of law, we termed it as the natural justice. And in natural justice, we included the same characteristics that is related to the due process of law. That is, the law must be just, fair, and reasonable, and the procedure also must be just, fair, and reasonable. That was what established in the Menka Gandhi versus Union of India case, and that is what we are going to discuss. The Menka Gandhi versus Union of India case, a very famous landmark case, just like the Keshwananda Bharti case. Let me just give you a brief background to this that case, and then we will go to the exact judgment what was given in the Menka Gandhi versus Union of India case. Menka Gandhi, her passport was impounded, means they taken away by the government of India in public interest. They say that you cannot travel abroad, and they say that yes, in the public interest, I am restricting your personal liberty. No reason were given to her. When she asked for the reason, the government refused to disclose them. She challenged this action of Supreme Court and arguing that it violates her right to personal liberty under Article 21. Because in 21, we have the right to freedom of right to personal liberty as well. We have right to life as personal liberty. So the issue before the court was to what was the issue before the court? The issue was to decide whether the state can restrict person's liberty, whether the state can restrict personal liberty without any reason, because no reason was given to her why her passport was taken away without any reason. Next, what was the procedure established by the law actually means, and must the procedure be fair and reasonable? These were the questions before the Supreme Court, and the Supreme Court ruling like made several historic declarations. The first, it says that Article 21 must be just, fair, and reasonable. And reasonable. That is, the government could restrict liberty through any law, but the law must be just, fair, and reasonable. It cannot be arbitrary, oppressive, or unreasonable. And also, beautifully, what came out is the golden triangle articles. It says the court said that Article 14, that is equality, Article 19, that is the freedom, and Article 21 are interconnected. And we have seen that when we talked about Article 21, I've said that Article 21, personal liberty, already includes all the fundamental rights under Article 19 and are even much more elaborative than that. And therefore, the court also held that the Article 14, 19, and 21 are interrelated or interconnected. And the third point that the court made, that the natural justice is a part of Article 21. Natural justice is the part of Article 24. And what does the natural justice mean? It means the person must be heard. Natural justice, let me write. And you should note down. It says that the person must be heard before serving the justice. The person must be heard. Point number one. Point number two, reason must be provided. Reason should be given. Reason must be provided for action that affect liberty. For action that affect liberty. If you're curtailing someone's liberty, you should provide reason. If not immediately, if not to the fuller extent, at least some sort of information you should provide. And you can restrict also this reason to provide provide a reason for the for someone restrictions of personal liberty is restricted. We will talk about when we move to Article 22, wherein if the reason is disclosed, the the detainee life is at risk, or the security of the state is at risk. So to that extent, the reason could be not disclosed, but it should be the region should be made very clear to the person whose right has been restricted as soon as possible. So the last point says that action cannot be secretive or arbitrary. It cannot be hidden. You cannot take covert action. Cannot be secretive or arbitrary. So these are the three important points that could be covered under the national justice. That is, person must be heard. That is, without hearing, you cannot reach to a decision. You cannot give any judgment. Reason must be provided for actions that affect liberty. And point number three, that action cannot be secretive or arbitrary. Also, the second point that was made was Article 14, 19, 21 are interconnected, and under Article 21, it must be, that is, indirectly due process of law must be followed. That is, it must be just, fair, and reasonable. That was has been evolved by the judgment given under Menka Gandhi versus Union of India case. Now let us talk about what are the rights that has been evolved under Article 21 from time to time, including the judgment of the Menka Gandhi and other subsequent cases. Right to live with human dignity, right to decent environment, because to live with dignity you require a decent environment, including pollution-free water and air, and protection of against hazardous industries. Right to livelihood, right to privacy, right to shelter, right to health, a right to free education up to 14 years of age, and that we'll see that is a part of Article 21A. A new article was inserted. Right to free legal aid, right against and free legal aid. We will see that we have the for free legal aid we have when we go to the that the when we discuss Supreme Court, High Court, we will see that how the free legal aid being exercised. Then we have right to speedy trial, we have right to against handcuffing, right against inhuman treatment, right against delayed executions, and there are so many rights: right to travel abroad, bonded against bonded labor, custodial harassment, medical emergency, free fair trial, information, hearing, reputation, against public hanging, so many rights, right against bar fitters, right to social and economic justice and empowerment. So many rights have been means inferred under the Article 21. So you can go through all this, because sometime in the objective questions it has been given that this right is counted under which article. So Article 21 would be the right answer. We will be going through the previous PYQs question. After the completion of this particular part, third fundamental right, we will see such type of questions are also coming. So you should at least read all these fundamental rights, that is 30 fundamental rights derived from Article 21, and just keep at the back of your head. Sometime it may come in examination directly. Some of them which were important, such as the free legal aid, health, shelter, right against handcuffing, free fair trial, speedy trial, all this thing you should remember. So I hope Article 21 is clear, and there should not be any confusion. Let us move to the last article of today's lecture. But before that, let us have a quick revision and comparison of the different important term of the Constitution. That is equality before the law, equal protection of the law, rule of law, procedure established by the law, and due process of the law. Equality before the law, it's a negative concept and prohibits discrimination guaranteed under Article 14. Meanings we have already discussed it. You may go through it one by one. Equal protection of the law, it is a positive concept, requires the state to treat equals equally and unequals differently, also under Article 14. Rule of law, supremacy of the law, equality before the law, no arbitrary power, a basic features of the Constitution, Kesavananda Bharati case. And this was taken from the Avid theory of rule of law, and government must act under the law. No one is above the law. Procedure established by the law. If there is a law and a procedure is followed, liberty can be restricted, taken from the Japanese constitution, and checks only the existence of law, not fairness or original interpretation of Article 21 before 1978. And due process of the law means law and procedure must be fair, just, and reasonable, and it is followed by the American Constitution, US Constitution. It includes both substantive and procedural fairness, protect against arbitrary laws, adopted indirectly in India through Menka Gandhi case. So equality before the law means everyone is equal in the eyes of the law, no special privileges, and equal protection of the law means law must apply equally, but reasonable classification is allowed. We have sufficiently discussed all this point. So now let us move to Article 21A, which was added by an amendment because Article 21 was present in the DPSP, where we say that the state shall make a special provision for the for the education of the children, and further in due course of time, right to education was also mentioned or interpreted under the Article 21. So the legislature, the parliament thought it would be better to make it as a separate dedicated fundamental right instead of a derivative fundamental right. So it added an amendment to the Indian Constitution in the 86th Constitutional Amendment 2002, and added an article just below Article 21, which is as Article 21A, right to education. And it makes education a fundamental right for every child between 6 years and 14 years, and it requires the state to provide free and compulsory education so that no child is left behind, no child is denied schooling due to poverty or discrimination. This right is implemented through Right to Education Act that was implemented in 2009, which ensures neighborhood schools quality teaching and 25% reservation for weaker section in the private school. In short, what we are going to discuss, that Article 21 guarantees that every child gets the opportunity to learn, grow, and build a better future. So it is related to article education only, and it is a simple article. So let us just go one by one. Article 21, right to education, added by 86th Constitutional Amendment Act 2002, came into force in 2009, and location it's just after Article 21. The state shall provide free and compulsory education to all children aged between 6 to 14 years in such manner as the state may by law determine. कैसे भी आप कोशिश करें, आपका ऑब्जेक्टिव यह है कि 6 से 14 साल के बीच के बच्चों को एजुकेशन फ्री में मिलनी चाहिए, कोई पैसा नहीं दे पाए, पैसे देने की जरूरत नहीं। और फ्री में कौन एजुकेशन लेगा? ऑब्वियसली जो पुअर है ना। वो आपने एक मूवी देखी होगी ना इमरान खान की, जिसमें एडमिशन पुअर्टी कोटा से एडमिशन लेने के लिए, तो दैट इज बेस्ड ऑन राइट टू एजुकेशन एक्ट. In simple word, every child between 6 to 14 years has the fundamental right. Now, if it is a fundamental right, you have a special power. If it is getting violated, directly go to the Supreme Court. Supreme Court will make some solution so that your right is exercised. To free and compulsory education, the government must ensure that no child is out of school. So free means no child should be denied education because of financial reason, even if it is not able to pay the fees, even in the private schools, even in the premium schools, should not be denied education. You should give him the education. Obviously, you have to the complete some paper formalities. You have to produce some document, prove that you qualify for right to free educations, because the government, it says that the state made by law, the state may by law determine how it is going to provide free education to all this. Now, if the government does not make any law, everyone, even the rich, will go and say that yes, under Article 21A clause 21A, I have my child has right to education. You should get him admitted. But there should be some law that who shall be qualified. The poorer section of the society shall qualify. So yes, It is the duty of the government that it is the duty of the government to enroll the children, ensure regular attendance, and prevent dropouts. That parents are not punished; they are responsibilities on the state. That means earlier the there was no more no fundamental responsibilities on the state provide the education, but now it has to ensure that the children are enrolled. It has to make provisions that it may organize the awareness campaigns to ask the parents to send their children to the school for education. They would not have to pay any fees or anything. They will directly get admission in good school so that their child could. So they would means in a way have to bring motivation in the parents to send their children to the school. And the major hurdle is about the money. And if no money is required for free education, obviously every parents would willing to get their child educated. So right to education act was adopted to basically to enforce article 21A. And in this right, the right of children for free and compulsory education act 9 2009 operationalize article 21A. Features is that no child can be failed till class 8. These were some of the features which were made to promote the education. Why? Because sometimes what happens that the childs who are like a little poor in grabbing the things, grabbing knowledge, they do not pass in lower classes, and due to they get failed. If they get failed in the low classes, or the teachers sometime out of their some personal revenge, some cases are also there that some personal revenge they fail the student, and demotivates the parents as well as the student, and they drop out from the school. So they drop out from the school and never returned. So in order to avoid that, this clause was added that no child will be failed till class 8. That is no detention policy initially. So now you have to initially there was no such policy. Now it is compulsory for you to at least a child who is getting admitted in class 1 should continue till class 8 without failing him. Now after she or he reaches to class 8, she is well aware. She has now generated so much of interest that she will definitely look forward to qualify to class 9 and class 10 out of her self interest, but prevent her the dropout up to class 8. And one of the reason is to not fail them. 25% reservation for weaker section in the private school, quality norms of teachers and infrastructures. These are some of the features of the RTA Act. And prohibition of physical punishment and mental harassment. Again, the reason being the dropout, to reduce the dropout cases. So why needed? Because the Supreme Court had interpreted that education as a part of Article 21 right to life, we have seen above. And however, it was only a directive principle under Article 45. So it was mentioned under the DPSP Article 45. When we go to DPSP, we will discuss why it was mentioned there. So the 86th Amendment Act made education as a fundamental right. Why? To ensure enforceability. Because we have known that the fundamental rights are enforceable by the code of law and not the directive principle of state policy. So I hope Article 19, 20, 21, and 21A is clear. There is no doubt in it about the understanding of this article. These were very simple to understand. I've discussed the important cases as well. The video is already being getting so long. Thank you very much for being and having patience watching me. If there is any confusion or any doubt or any query you want to raise, you have in the beginning you have the link to our the WhatsApp community. Join there, ask us the question. We'll feel free to ask, and we are happy to answer you there. Till then, good luck, and we will meet in the next video. Thank you.